Sweetheart, be mindful of your health. Dear products Nadia Makeup, I welcome you to Sigma Health and Beauty. You can call us the Beauty Embassy. Who pursue beauty more revealed with quality makeup products. There is only one place, the Sigma Health and Beauty 2022 Ghana Makeup Awards Beauty Retail Business of the Year. Of course, we are the defending champions. World-class makeup brands and Quaniton, you name it. Maybelline, Dark and Lovely, House of Tara, and many more. Your professionalism in the beauty industry is unmatchable. Rami ensure the proper way of applying our products. Sigma Health and Beauty, Yewa Accra, Makola, Georgina Stores, and Rollins Park, Gate 4. Fryer in 0248 138 596 and 0201 408 186. Or visit our online shop at www.beautyavenuegh.com. Sigma, your beauty, our joy.
Welcome to the Ghana ICT Hub, a partnership between MTN Ghana and the Government of Ghana.
Also per Section 49 of the Public Financial Management Act 216, Act 921, is the Minister of Finance
who has the mandate to authorize the Controller and Accountant General to invest any sum standing on the consolidated fund. Mr. Speaker, I would like to take you through the processes. That's the workflow of the disbursements of funds at the Scholarship Secretariat. Request for release of approved budget sent to the Ministry of Finance through the Office of Government Machinery. The Controller and Accountant General processes and credit Scholarship Secretariat's account at Bank of Ghana. Scholarship Secretariat then sends payment requests to the Controller and Accountant General to transfer funds to Ghana's missions abroad to pay for scholarships through Bank of Ghana. On receipt of funds from Bank of Ghana, the Treasury at the respective Ghana missions abroad sends payment instructions to scholarship beneficiaries and institutions in the host countries. And Mr. Speaker, finally, periodic monitoring and payment reconciliation by the Scholarship Secretariat are made with the missions abroad. Thank you.
Yes.
Speaker, there will be no follow-up.
Very well. The next question is to be asked by the Honourable Member for Clotte Colley. Dr. Daniel. Oath 1399. Very well, yes. Available leader.
Speaker, thank you. Speaker, I rise to ask the Minister of State at the Office of the President the outcome of the criminal investigation of insurance fraud against Mr. Kingsley Ajimai, the Registrar of the Scholarship Secretariat, regarding his management of unique life assurance brought to his appointment. Thank you.
Yes.
Thank you, Mr. Speaker. Mr. Speaker, the Registrar of Scholarships, Dr. Kingsley Ajimai, has no knowledge of any such investigation against him and awaits further details on the stated case from my honorable colleague, Member of Parliament for South Dine. Thank you.
Yes.
Speaker, would the Minister of State be, this will be an opinion, so I'll rephrase. Pursuant to an RTI request by myself to the National Insurance Commission, they have indeed agreed that there is some investigations going on, the report of which they are yet to supply me. And therefore, I want to suggest to your ministry to do some follow-up by the National Insurance Commission, who assists with the matter, for further briefing. Mr. Speaker, thank you.
Thank you, Mr. Speaker. Mr. Speaker, the issue of fraud and criminality is a very serious issue, and we haven't cited any report from the Insurance Commission to that effect, so I cannot speak to it. And having had a personal discussion with the Director for Scholarship Secretariat, so nothing of that sort happened. So if you have any further information, you can bring it to my office. Thank you.
There will be no further supplementary question on this matter.
Very well. I'll go to question number 1530. Honourable Member for Clotte Colley. He's not in the House. Very well. The answer is provided and published. That will bring us to the end of question time. Honourable Minister of State, thank you for attending upon the House to answer questions. You are discharged. Very well. I'm being advised that the answer for question number 1530, asked by the honourable member for Clotte Colley, has not been published. In that case, the question will be relisted to be asked by the honourable member if she's in the House. Yes, Honourable Majority Leader, what next?
Speaker, there are a couple of papers to be presented, but the Deputy Attorney General standing in for Attorney General has been with us for quite a while. So perhaps would allow her to move the motion for the second reading of the Interstate Succession Bill. That is item listed as 13 on page 5 of today's order paper.
Very well. Item 13. Motion by the Honourable Deputy Attorney General. You may do so on behalf of the Minister. Yes, please. Speak to the mic.
Mr. Speaker, I respectfully move that the Interstate Succession Bill 2022 be now read a second time. Mr. Speaker and honourable members of Parliament, the purpose of the Interstate Succession Bill 2022 is to remove the anomalies in the present law, PNDC Law 111, relating to interstate succession, and to provide a uniform interstate succession law that will be applied throughout the country, irrespective of the inheritance system of the interstate or the type of marriage that has been contracted. Mr. Speaker, honourable members of Parliament, there is little or no protection in the customary law for a surviving spouse. Neither spouse has a right to the property of the other, and children in a matrimonial system bear maintenance by the customary successor of their father. Honourable Speaker, changes in the Ghanaian family system have rendered the present law on interstate succession outmoded. The nuclear family has gradually eroded the significance of the extended family in a manner similar to what pertains in the Western world, thus giving the nuclear family greater preeminence, which is not reflected in the existing laws of succession. Mr. Speaker, the customary law concept of marriage does not regard the wife as part of the economic unit of the husband. As a result, the wife's claim to a husband's property is very limited. However, there is currently a shift towards the involvement of the wife in the economic activity of the husband, and this has considerably reduced the influence of family in interstate succession. Mr. Speaker, the growing importance of the nuclear family brings with its own logic of moral justice. The rationale is that a surviving spouse deserves to be compensated for the services rendered to the deceased spouse. Mr. Speaker, and I use spouse advisedly and not the wife, and that there is a need to satisfy the expectation of both spouses by giving the property of one to the other on the death of the spouse. Mr. Speaker, honorable members of this House, the Interstate Succession Act 1985, PNDC Law 111, does provide some protection beyond the customary law. However, PNDC Law 111 was an innovation at the time of its enactment and was hailed as a source of relief for spouses who were often victims of ejection and other forms of persecution. The law indeed was intended to prevent members of the extended family from taking over the assets of the deceased for their own use to the detriment of the surviving spouse and children. Some of the provisions, however, have proved quite inimical to the interest of the immediate family of the deceased. The provisions on the fractional distribution of the estate have been very difficult to implement. The specific portion of the estate fixed by the current law to devolve to the spouse, irrespective of the number of spouses, is also problematic. In other words, the current law does not make provision for where there is a polygamous marriage, where the deceased is survived by a number of spouses. In such situations, the spouses are all compelled to share the same fraction that the law stipulates for a surviving spouse. The requirement that the matrimonial home be shared between the surviving spouse and the children of this, some of whom may not be the children of the surviving spouse, has also often resulted in acrimony. Mr. Speaker, honorable members of this House, PNDC Law 111 is also silent on the issue of joint acquisition of property and how this should affect the fraction of the estate that a surviving spouse is entitled to. The surviving spouse may therefore lose out on any investment made in the property, and additionally, no provision is made in the existing law for dependent parents or dependent children of the deceased who are still in school. Mr. Speaker, the present bill before you seeks to address the inadequacies of PNDC Law 111 and thus provides for a substantial portion of the estate of the deceased to devolve to the spouse and children, which at present is not the case. The bill recognizes the problem with customary law and the existing codified law in relation to succession and seeks to protect the interest of the surviving spouse and children of the deceased, as well as dependent parents. This is intended to make the law more responsive to the needs of the immediate family of persons who die interstate. Mr. Speaker, honorable members, a surviving spouse is to have a 50% share in the matrimonial home, and where the spouse partly owns the matrimonial home, the estate available for distribution does not include the part owned by the surviving spouse. And this is the import of the bill before you. A novel feature of the bill is also the distribution of joint property other than a matrimonial home. And so where the intestates own other property, in addition to the matrimonial home, and the surviving spouse also owns a part of that additional property, only the part of that property owned by the interstate is available for distribution. The bill, however, I must emphasize, does not apply to stool, skin, or family property. Mr. Speaker, another novel feature of the bill is the protection the bill offers to dependents of the estate, particularly children who are in school or learning a trade. The bill also provides for situations where customary law is inapplicable in the case of a foreigner who has made Ghana his or her home. In such instances, the rules of private international law may require the application of Ghanaian law to the distribution of the property of that foreigner. The bill provides that the portion which is required to devolve in such scenario in accordance with customary law should devolve to beneficiaries who are entitled to share the residues of the estate. Mr. Speaker and honorable members, the passage of the bill will to a large extent offer the required protection to a surviving spouse, makes provision for the devolution of properties in the case of polygamous marriages, will also make provision for dependent children, dependent parents, and other beneficiaries of the estate who die interstate. It is therefore respectfully my expectation that this honorable House will assist in attaining the intended objective of the bill by passing the bill. I thank you very much, Mr. Speaker.
Very well. May the chairman of the committee now second and present the report of the
Thank you, Mr. Speaker. Mr. Speaker, in the absence of my chairman, I seek your leave to rise in his stead. To second the motion moved by the learned Deputy Minister of Athens. And in doing so, I humbly request the table office to capture the entirety of the report while I take the House through the observations and end the report with the conclusion. Under the observation, Mr. Speaker, I would like to take the House through the devolution of estate of a Muslim interstate. Mr. Speaker, the committee received memoranda and presentations from the Muslim community expressing concerns about the failure of the bill to acknowledge the Islamic system of inheritance as contained in the Holy Quran and also recognized under the Marriages Act 1884 to 1985, Cap 127. They aver that Muslims, like practitioners of other religions, are protected under the Constitution, specifically Articles 21, Clause 1C and 26(1) of the 1992 Constitution, which guarantees the right to practice any religion of choice and to manifest such practice. The federal submit that in recognition of these inalienable rights under the Constitution, that the Marriages Act 1884 to 1985 provides that on the death of a Muhammadan whose marriage has been duly registered under this part, succession to the property of that Muhammadan shall be regulated under law. Section 8 of Cap 127. In our view, the bill in its current form has failed to acknowledge the interest of Ghanaian Muslims to practice, to manifest, profess, enjoy, maintain and promote the Islamic system of inheritance provided under Cap 127. The committee, however, expressed contrary opinion. In the view of the committee, the bill is only also seeking to repeal the Interstate Succession Act 1985, PNDC Law 111, the laws relating to marriages in Ghana Act 1884 to 1985, Cap 127, the marriages of the Mohammedans Ordinance, Cap 129, are still in force. Consequently, Section 28 of Marriages Act 1884 to 1985, Cap 127, is still relevant to the devolution of the estate of deceased Muslims who registered their marriages under Cap 127. The committee further contends that any attempt to make exceptional provisions for Islamic religion under the proposed legislation will be contrary to the provisions of Article 17, Clause 2 and 35, Clause 5 of the 1992 Constitution on equality and non-discrimination. In conclusion, the committee has thoroughly considered the memorandum accompanying the bill, indicating the weaknesses in the current interstate succession law, ICT Law 111, as well as the mischiefs the bill seeks to cure. The views of the general public were also sought as part of the consideration process of the bill by the committee. After extensive deliberations and stakeholders' engagement, the committee concludes that a need for a revised law on interstate succession law in Ghana is long overdue. Accordingly, the committee recommends to the House to adopt its report and pass the Interstate Succession Bill 2022 into law in accordance with Article 106 of the 1992, subject to the amendment proposed attached as Appendix A. The committee further recommends for extensive public education after the passage of the bill into law to ensure smooth implementation and enforcement. Respectfully submitted.
Honourable members, First one to Standing Order 127. A full debate shall arise on the principle of the bill on the basis of the explanatory memorandum and the report of the committee. Now, yes, it is after. This that I open the debate. So I'll now invite you to make your statement, your comments.
Speaker. Speaker, thank you for the opportunity to add my voice to the motion that was ably moved by the Deputy Attorney General and seconded by the Vice Chairman for the committee. Mr. Speaker, in doing so, may I make the following observations. Mr. Speaker, in the report, we are informed at pages 2 and 3, particularly from paragraph 4, subparagraph 1, 2, 3, and 4, that the existing law is odious, it's become anachronistic, it's outlived its usefulness, and therefore there's the need for a fresh legislation to cure the maladies, the deficiencies, the lacunas in the existing law. Mr. Speaker, what is interesting is that if you look at paragraph 4, subparagraph 1 of the report, it is stated that some of the provisions of the law, including the fractional distribution of property of the deceased, are proving difficult to implement. Also, the law has no provisions for polygamous marriages in cases where a number of spouses are survived by the deceased. The existing law is also deficient in the devolution of assets jointly acquired by both spouses, as well as where there are dependent parents and school-going children of the deceased. Mr. Speaker, in paragraph 4, subparagraph 5, it goes further this way. The bill was therefore introduced to enhance the protection afforded surviving spouses beyond what customary law and the PNDC law 111 provides. Mr. Speaker, but the provisions contained in the bill still use fractions and decimals. They use percentages. So we may still be running into problems in trying to compute and distribute the estates pursuant to the new law. So I may have to draw the House attention to perhaps come up with a proper manner of formulating the distribution formula, so we don't run into the present problem that we have identified. Mr. Speaker, then there is the suggestion or proposal by the promoters that we should identify and give credence to some category of spouses that we have identified as estranged. Mr. Speaker, we are told that the family is the single most important unit of society. That is why, indeed, Mr. Speaker, as part of our laws, Matrimonial Causes Act, if you intend to proceed to divorce your wife, you are mandatorily required to go back and attempt reconciliation. If that further fails, then the court will be minded to proceed. So if as a House we are called upon to legislate and, as it were, give parliamentary enactments to persons who have detached themselves from matrimonial homes, from marriages, and are living elsewhere and are not performing their matrimonial duties, and give them anchor in the law, I believe that we won't serve the Ghanaian people well. So the committee unanimously agreed that that provision, that intendment by the proposers of the bill, be completely taken out. You are a wife or you are not. We cannot agree that and a wife whose status in the home has fallen into estrangement be given some parliamentary approval by this legislation. Mr. Speaker.
Honorable, can you guide us? If there's no divorce, is an estranged wife a wife or not a wife?
Yes, Mr. Speaker. Let the family or the courts make that determination. We in this house categorizing the status of spouses as a spouse who is on duty and a spouse who is not on duty. When you are on duty, you are on duty. If you are not on duty, you are not on duty. And so let the family and the courts. Yes, if you are, let the court determine that. So I think that as a house, we ought to be guided in giving effect to that proposition. Mr. Speaker, the other key important matter that I want to touch on is in respect of the observations made by the committee under paragraphs 7, from paragraph 7 sub 1 all the way to paragraph 7 sub 5. It's in respect of the status of marriages contracted under the Islamic law. These days, Mr. Speaker, we are minded not to name it the Mohammedan's law. We are encouraged to call it, even though that is it in the statute.
Don't encourage any illegal intrusion into the law. The law is Marriage of Mohammedans Act. If we want to amend it, we should amend it. If we start admitting other people's interpretation, we may confuse what the law is. I agree what their challenge is, but we can still take steps to amend it. But as it is now, the law is Marriage of Mohammedans Act, and that's what we should recognize, nothing else.
Speaker, I agree with you. I cannot litigate this matter. Mr. Speaker, so the issue has been the difficulty in distribution of estates of persons that died and their property falls into intestacy under the Mohammedans Act. And the observations has been made that even provisions of Cap 127 have been repealed in line with PNDC Law 111 when it was passed in 1995. But there appears to be some very little community education in respect of that. So persons still suffer the iniquities of property distribution when such situations arise. So we are encouraged that upon the passage of this bill into law, there must be massive community engagement to educate our Muslim brothers and sisters to take steps to register marriages contracted under the Mohammedans, marriages under the Mohammedans Act, to be able to enjoy the benefits that the law and the comfort and protection that the law provides. Mr. Speaker, I want to raise, if I may comment on one other matter and make a few corrections. Under, if we go to page 10, under paragraph 7 sub 5, humbly, I think the subheading should be prohibition of ejection of a spouse from the matrimonial home upon death of an intestate. Yes. Yes. Because the heading, the body of the paragraph is does not gel well with the heading. The heading appears to be talking only of the spouse, but if you go to the paragraph, we are speaking of both the spouse and the children. And then also if you go to line 3, it should read from being ejected out of the matrimonial home. It's the spouse who is in matrimony, not the children. And then line 2 on paragraph 11, it should also read place of abode which was shared with the disease. Which was shared with the disease. Because at this time we are speaking of somebody who is dead and gone. Now, the other issue, Mr. Speaker, I want to raise is in respect of the provision regarding where the property devolves under custom to the beneficiary. And I say this because under every customary law, it is children who inherit their father at custom. Now, I litigated the matter all the way to the Supreme Court. I lost. I won at the High Court, but I lost at the Supreme Court on the following grounds. My argument was that where a beneficiary, where an intestate is survived by a beneficiary, a child, who is already provided for under the law, but at custom, the devolvement at custom will still benefit that child, then it is inequitable, because the family has then been left out for being provided for. Because the inverse had been the case, and the law came to cure it, that families were depriving children share. And therefore, if the law has now reversed that trend, then the extended family ought not to lose out. But that was the case in Togbe Akoma and Ken Mensah versus Mrs. Gladys Mensah. When we argued the matter before the High Court judge, he agreed that the interment of the house, of the framers of the law, cannot be that a child will benefit twice under the different provisions in the law. And I have the judgments here, the Supreme Court judgment. I may read portions just to anchor the debate. But upon appeal, the Supreme Court disagreed that because the law did not use the word family and was specific in respect of the use of child, under every customary law, it is the child who will benefit under the 9/16th, and also benefit under the portion that would have gone to the surviving parents of the deceased intestate, because there was no surviving parent. So that 25% will devolve onto the child at every customary law, because every at customary law they inherit their fathers. So I think that as a house, we need to be guided that these are some of the difficulties that the legislation creates sometimes. You want to solve a problem, then you end up creating another problem. Because I think that sincerely, it is not the interment of the framers that the family should lose out. And finally, I think that the present legislation, Mr. Speaker, is I say this without hesitation, with the important role that the extended family continue to play. And so I think that we need to, as a house, it's a very important legislation, but we need to enact the law in such a way that the extended family will still be relevant in the scheme of things because of recourse to Article 11 of the Constitution, customary law practices in all, which are all still regarded as part of our laws. And so, Mr. Speaker, to conclude my remarks on this matter, let me just read what Akoto Bamfo JSC, who read the lead judgment in that case, said. Mr. Speaker, in portion, he started this way. He said the wife applied for and was granted letters of administration, and then proceeded to distribute the estate as the sole administrators, taking the view that they had been left out of the administration without any basis, the head of family and the successor commenced an action before the High Court for a declaration that the family was entitled to a 25% share of the residue of his estate and another for an account among other reliefs. This was granted. Mr. Speaker, upon appeal, these were the submissions of us, the lawyers. Mr. Speaker, in his submission before this court, learned counsel for the appellants contended that the learned trial judge could not be faulted, for he made the right conclusion, having appropriately considered the issues relating to the interpretation of the relevant provisions of the Interstate Succession Act, particularly which gave expression to the intentions of the framers of the Act. He further submitted that the learned judge's approach was in consonance with the modern purposive approach to the interpretation of statutes. He argued that since it was the intention of the framers of the Act to correct the anomalies existing in the inheritance system pertaining to the custom of the various communities, it was inconceivable that the same person, the same piece of legislation, will make provision for the surviving child to benefit twice, whereas the family had absolutely nothing. In reference to Section 5(1) of the Act, he argued that since under subsections A and B thereof, it was abundantly clear that the surviving child had been adequately catered for, an interpretation which additionally vested the residue in her will be absurd and contrary to the intent of the framers of the law. He accordingly urged that the decision of the High Court be restored. In answer, the learned counsel for the respondent submitted that the law was settled and that there was no ambiguity as had been established in a long line of decided cases, as well as the text of text writers on the subject that under every custom, children were the sole beneficiaries under their patrilineal system of inheritance. The ratios are there, but I just want to apprise the House of some of the difficulties that some of these provisions can spring when we put them into effect. Mr. Speaker, with these words, I thank you for the opportunity.
Yes.
Thank you, Mr. Speaker, for the opportunity. Mr. Speaker, let me read the entire paragraph 5 of the report of the committee before I continue. It's on the object of the bill. The object of the bill is to remove the present law relating to interstate succession and to provide a uniform interstate succession law that will be applied throughout the country. The emphasis on irrespective of the inheritance system of the interstate and the type of marriage contracted. Mr. Speaker, Article 11(3) of our Constitution provides that customary law, including those determined by the Superior Court of the Judicature, are applicable in various instances, and goes ahead to define customary law to mean rules of law which by custom are applicable to particular communities in Ghana. Mr. Speaker, this bill seeks to, the intent of the bill seeks to protect spouses and children of parents who die intestate, and the inheritance system that this law seeks to regulate. Mr. Speaker, every customary law is recognized by our law, and every community has set customary processes that they follow So if this bill seeks to apply a uniform system, irrespective of the inheritance system which has been in existence for centuries, to protect spouses who are affected, we may run into challenges. Yes, we may. We may. Because you see, Mr. Speaker, leader. Secondly, Mr. Speaker, I'm drawing the AG's attention to the fact that the provisions of the Constitution do recognize customary law, and every customary process is unique within certain the community within which it applies. Secondly, the AG spoke about joint acquisition. I believe that joint acquisition can be determined by courts of competent jurisdiction. If you so believe that you contributed towards the acquisition of a property during the subsistence of a marriage, then you must go to court and lead relevant evidence to support your claim under that acquisition. Thirdly, Mr. Speaker, our family systems have been developed or has evolved over the years. And my colleague, Dafia Meko-Roxon, spoke about our strong family system, especially if you read cases like Labi and Keto and Co. You get an idea of how our families regard our family system and their contribution towards the acquisition of properties, and also sponsoring some of the members of the family who directly benefited from family property and its devolution during Interstate. Thirdly, this same PNDC law, there's a PNDC law on the Head of Family and Accountability Act and so on and so forth. The Speaker, yes, government may have the right intentions by bringing this bill. I support it. I want spouses to be protected. I want children to be protected. But we should not lose sight of the fact that customary law ought to be respected, the processes for inheritance under those customary systems ought to be followed. Like I said earlier on, otherwise somebody will go to the Supreme Court after the passage of this bill and say that, look, you can't apply a uniform customary law or inheritance system across the country. When you go to Yenji, they may have their set processes of inheritance. You go to Asante, we may have. You go to Ewe, they may have. So it's just a word of caution. The intendment is good, but they must proceed it well within the context of the Constitution. I thank you very much, Mr. Speaker.
Yes. Who West.
Thank you, Mr. Speaker. Mr. Speaker, I also rise to support the motion and share a few thoughts on the interstate succession law that your committee brought to this House. Mr. Speaker, I would like to correct one item on page 2 of your committee's report. The first line, where we have Togbe Teple Hodo, the fourth National House of Chiefs. The word there should not be Togbe Teple Hodoi, it should be Togbe Teple Hodo, H-O-D-O, and the title is IV, the fourth. So if that can be corrected in the report. Mr. Speaker, let me commend the committee, your committee, for a good work done, and also thank the Deputy Attorney General for bringing this law to the House. Mr. Speaker, I particularly share with paragraph 7.5, where there is a prohibition of ejection of spouses from their matrimonial home when one of their spouses die interstate. We know in this country that most often we heard and we've read from the news portal that some, especially the women, are ejected from their matrimonial home when their husbands die, to the extent that some of them are beaten by the family of their deceased husband. This, I believe, even though we have the PNDC law 111 that we all applauded in those days when I was young, and you hear PNDC law 111, the whole world thinks that that was the best law. But after 38 years of existence of this law, we need to amend part of this law or completely bring in a new law, which I believe that will curb and also prevent our mothers, unfortunately, who lost their husbands in course of the marriage. Mr. Speaker, I also want to share with the committee's report where we need that is in page 11, where we need to educate our populace, we need to educate our citizens about this. When we pass this bill, we need to educate them, because most often than not, we pass laws in this house and people do not know the laws that we pass. And therefore, they continue in their own ways of doing things. And so I want to encourage the AG department, the civil society organization, as well as NCCE, that when we pass this law, it should not just stay on our shelves, but rather we should know that there's a law in this country that prevents our mothers and sometimes our fathers being held and removed from their homes when they know very well there's a law that prevents that until the property are shared. Having said that, Mr. Speaker, one of the things that I've also want to share, and I share with the Honorable Roxanne, has to do with the Mohammedan's law or the Mohammedan's marriage. Mr. Speaker, we have different faiths and religions in this country. And one particular religion says that you can marry 5 women, and if you don't register their marriage, that is their tradition, that is their custom, that is their belief. Now we are making a law that regulates and bring all faiths, all customs, all traditions under one roof. In my hometown, in my area, polygamous marriage, you can marry. I'm a Christian. I marry one anyway. We can marry as many women as you want, and that is legitimate. And so sharing the property should be done. And so with the Muslims or with our brothers from the Islamic faith, if you have not registered it under their law, it's also marriage. And also, I've not seen the cohabitation. A man who with that, Mr. Speaker, I thank you.
What cohabitation? Under the bill where cohabitation started, they dropped it. Yes, Honorable
Speaker, the Speaker, this House, on at least 3 different occasions, has attempted to craft this bill. On the 3 previous occasions, we've run into serious turbulence and we've had to abandon the enterprise. I think that we really need to make a determination on this. The Speaker, I've listened to colleagues who have raised issues about the strength of our customs and traditions as captured or as provided for under Article 11. The Speaker, I agree we need to respect our customs and traditions, because we belong to communities, we belong to ethnic groups which are guided and regulated by our traditions, customs, and practices. It is out of that we are referred to as Ghanaians. So we're not Ghanaians first. I am an Ashanti first, and from that, I belong to Ghana. I become a Ghanaian by virtue of the fact that I'm an Ashanti, I'm from this region, and I come from this settlement. So our traditions, customs, and practices must be respected. But we should also be mindful of the fact that society is dynamic, which is why, in spite or notwithstanding the strength of Article 11, there is also Article 39(2) of the Constitution, which, Mr. Speaker, with the greatest respect, I want to quote. It says, "The state shall ensure that appropriate customary and cultural values are adapted, not adopted, adapted." So, Mr. Speaker, you can adapt with the necessary modifications. They are adapted and developed as an integral part of the growing needs of society as a whole. And in particular, that traditional practices which are injurious to the health and well-being of the person are abolished. So, Mr. Speaker, with this, we will be smithing our traditional and customary practices. Those which we find injurious must necessarily be abandoned and abolished. Mr. Speaker, let me relate to a recent case. My kids used to be at GIS. They were friends to two pupils there. They used to come to our house. The Speaker, the woman was a housewife. That was the wish of the father or the spouse. The man transitions, and just 3 days after the man transitioned, the family descended on them and sacked virtually the woman from the house. Today, as I speak, the children have to abandon the school. They are in a local authority school. How just is that? 3 years ago, a friend to my wife, who was married to a medical officer. The medical officer, again, reduced the woman to a complete housewife. He had gone to procure some facility for his hospital where they were living. The man goes, he undergoes a process, medical process. He didn't survive. The family, upon hearing, rushed to the house and said to them that it's the upstairs of that home, that is their matrimonial home. The hospital was downstairs. And they said that is all part of the matrimonial home. And the Speaker, it took the effort of the medical officers at Konfanochi to come together and assist this woman by providing her with legal counsel to be able to stand on her feet to fight this case. It's not even terminated yet. Why do you allow such practices? The Speaker, as I speak now, you should know, I wouldn't want to mention any name, but something has happened recently. And then the man has started the development of about 5 houses. They have not completed any of them. The man transitions, and as we speak now, there's a rush to take over the property of that man, who transitioned just about 2-3 months ago. What is this? And we say that we should be content with this because it's part of our traditions. Mr. Speaker, so I believe we should be making good progress. Where we are now, we have identified the mischief, which is what the Deputy Attorney General has related to. Incidents within polygamous marriage, surviving spouses and children, what to do with them, especially children who are schooling. The Speaker, joint acquisitions of property and dependent children, people born outside marriage, you bring them into this world. And you have a duty to take care of them. The person transitions and we want to abandon that person. Mr. Speaker, some time back, we lost one of our own. The man had a wife. Well, it was estranged. The woman was living elsewhere. And upon the transition of that woman, upon the transition of that man, the wife, who at the time was in London, then came and demanded whatever was outstanding for the Member of Parliament. In the meantime, even before the woman came, a cousin of that MP had come to me to inquire about giving to the family. And even the woman, when eventually we got what was due to that, that man, immediately we handed the check to her. He told me not to even discuss it with her own children. Here. The next day, she left. And I knew of a young child of that MP. The woman told me that when he came to buying coffin, the boy did not contribute. So I should leave it. And she went away with it. These are injurious practices that we must confront. We can't hide under traditions and customs and protect them. Mr. Speaker, I agree that we should have serious dialogue on some of these matters. Remember, when we came crafting the Children's Act, this same issue, one issue cropped up, that is between Christians and Muslims, about the age of consensual sex. Some people wanted it lowered to 12 years in situ. We aren't. Society is changing. And our own society is changing. Mr. Speaker, I'm not too sure that when perish the thoughts that, but certainly it may happen. It will happen that the Speaker transitions. I'm, for instance, saying him. Perish the thought I've said. Touch wood.
Well, it will happen.
That's what I said.
That to be much later.
Absolutely. Absolutely. Mr. Speaker, if it should happen that the Speaker transitions, you, in your upbringing, I'm not too sure that you want your children to walk that same path.
My children to do what?
To walk the path that you did walk. You want some massive improvement. And you want some modernity to be introduced so that your children will not suffer. You want some recognition to your parents, that is, if they will be surviving by then. But you don't want the extended family to take over and then be in a position to be dictating that we are giving your children 5% or 10%. The converse should hold if it should come to that. But Mr. Speaker, I was just saying that we need to engage in further education. But the good thing is, at this stage, we are talking to what the Constitution provides in Article 106 Clause 2, which states the bill should be accompanied by an explanatory memorandum setting out in detail the policy and principles of the bill, the defects of the existing law, which is what the Attorney General, the Deputy Attorney General, is talking to, the remedies proposed to deal with those defects and the necessity for their introduction. That's where we are. As for the bolts and nuts being raised by the Honorable Dafema, when we come to the consideration stage, we'll deal with them. But I'll pray as once we cross this hurdle to have further engagements with these other cross-sectional representation before we move forward. Because, the speakers have said, on 3 different occasions we have attempted to do this and we have failed. We cannot fail the 4th time. And I would want to hope that we'll be able to deal with this before the House adjourns senior DA this meeting. Because, as you do know, the next meeting is a budget meeting. If you're not able to do it, it will then have to spill over to 2024. So let's help ourselves to be able to deal with this. The sore point is really the proportions for the distribution. But we are dealing with proportions all the time. Get funds from that, we deal with proportions. We deal with proportions with health insurance. So, Mr. Speaker, let's confront the reality. And I believe that with goodwill on all sides, we'll be able to overcome. Mr. Speaker, thank you very much.
Very well. Honorable Attorney General, to you other comment, conclusion comment.
Thank you very much, Mr. Speaker. I have listened carefully to all the debates, and particularly the closing remarks, if I should say, of the majority leader. And I must say that I share entirely in all the arguments that have been made, and ordinarily would not have said much, except to highlight a few things that have come up as a result of the debate. The first being that to highlight the fact that the present bill does not seek to speak to customary law in general. It only speaks to situation of intestacy. And so issues concerning marriage and its incidentals are clearly outside the purview of the present bill. And that is the highlight I want to make. Mr. Speaker, yes. Mr. Speaker, let me place on record my unequivocal respect and acceptance of customary law. But Mr. Speaker, it becomes interesting when we become a stickler for customary law, looking at the historical evolution of our customary law. If we were to stick to the peculiarities of the various customary law, Mr. Speaker, we would not have been where we are. Our human rights regime would not have been where it is. Clearly, issues of customary law have had to give way to issues of human rights. And particularly the import of this bill is to emphasize some of these rights, including the rights of children, particularly, and of course, the rights of women, even though spouses under this bill also includes men, Mr. Speaker. Mr. Speaker, sometimes when we make these arguments about customary law, we fail to also mention that these issues of customary law, the responsibility of the extended family, which was commensurate with this uniqueness of customary law, has also diminished. For instance, the previous responsibility of uncles and the extended family towards the children now have also diminished. And so we cannot continue to hold on to this customary law of leaving the extended family to match enjoyment of the estates of them, when we have failed to continue to protect the responsibility of the extended family. In other words, Mr. Speaker, the truth is that presently the importance of the nuclear family is paramount. And so when we make arguments that we need to respect and make way for the peculiar customary law, my Lord, Mr. Speaker, my argument is that this present bill is not a closed circuit for anybody. If you are not satisfied, my Lord, there is the option of making a will. In fact, when a person makes a will, a very deeply entrenched dogmatic person in customary law makes a will and purports to even give all the assets to the children, my Lord, then the argument of customary law fails, because we are enjoined by law in the situation where such a person makes a will to respect the tenets or the provision of the will. And nobody then is here to be saying that if we did not respect the customary law, the peculiar customary law of the country. And so my argument, to sum it up, is that this bill does not seek to regulate customary law in its entirety. It only regulates intestacy, where the person has failed to make a will. In other words, much as I implore all of us to be very comfortable with the provision of the bill. If you are not happy, my Lord, the door is not shut on you, Mr. Speaker, the door is not shut on you to make a will, to decide to stick to the very peculiar customary law in which you are coming from. Even though, my Lord, there's some customary law, I must say, have made some inroads in protecting the rights of children and women. We should not also be oblivious to the realities that some of these customary laws have also not augured well for the rights of women and children. And so clearly, the Honorable House will have a very open mind about the present bill, and I pray that you give it a positive consideration onto its passage. I thank you, Mr. Speaker.
Very well, members. Before I put the question, I just want to share a few observations. The observations I share are not about the law per se. It's about attitudes that we have developed over the years, probably out of the practices. For example, the law uses the word spouse, but in my own practice and around us, anytime a surviving spouse is male, he has serious difficulty claiming the property of the deceased wife. All the time. Either the society will ridicule you or the family will fight you. So even though the spouse, definition of spouse is gender neutral, in practice it is it means female. The surviving spouse actually means female surviving spouse. And that leads to the next bad practice I've observed over the years. The leader mentioned two situations where family moved in to take possession of a property of a deceased person. Meanwhile, the existing law provides for using the police to protect surviving spouses. And yet either the police will not come in or the surviving spouse fails to take advantage of the law. I don't know whether because we don't know the existence of the law or we simply want to avoid conflicts at that stage. But most of the time, the challenge is that the law is not providing protection. It is because we are failing to use the law to protect ourselves. That said, I encourage all of us to write our wills. Even for those who want the custom of their community to apply, just state in your will that upon my demise, the Santi custom or the Ewe custom should be applied. Or, even if you're a Muslim, you can say the provisions that's in the Quran should be applied to distribute my estate. And that will be it. On that note, I put the question. All in favor of the House adopting the report, say aye. All against, say no. The ayes have it.
And asked to provide for interstate succession and for related matters.
The interstate succession amendment law is hereby read the second time. Yes, Honorable Majority Leader.
Mr. Speaker, if you can deal with item listed as 7. 7.
Yes, please. Item 7. Presentation of papers. A, by the Majority Leader.
Budget performance report in respect of the Office of Government Machinery for the period January to December 2022.
The report is duly presented to members. B, by the Chairman of the Committee.
Report of the Committee on Lands and Forestry on the Wildlife Resources Management Bill 2022.
The report is duly presented for distribution to members. C by the chairman of the committee. The Committee on Energy and Mines, yes.
Mr. Speaker, with respect, if we could stand down C, D, and E. C, D, and E.
Very well.
But to urge, Mr. Speaker, to urge the Committee on Trade, Industry and Tourism. Now, this bill has come to this House, and on their own recommendation, they've indicated that it's an urgent bill, which means that the report should come for us to debate and then do the consideration of the bill. Mr. Speaker, I can't understand what is happening. It defeats the purpose for you telling this House that it's an urgent bill, and after failing to work on it and submitting your report. I think the Committee on Trade, Industry and Tourism, especially their leadership, should be spoken to, and I'm charging the Chief Whip. I'm charging the Chief Whip to engage them so they'll be able to submit the report, maybe tomorrow. So we'll begin to deal with them. Otherwise, it loses the purpose, and time is running.
Very well. The presentation of the reports C, D, and E are hereby deferred. Yes. Any other matter? Otherwise, I'm bringing proceedings to a close. Very well, honorable members. The House is adjourned till Thursday, June 22nd, 2023, at 10 o'clock in the forenoon.
Sweetheart, be mindful of your health. Dear products na makeup. I welcome you to Sigma Health and Beauty. You can call us the Beauty Embassy. Who pursue beauty more revealed with quality makeup products. There is only one place. The Sigma Health and Beauty 2022 Ghana Makeup Awards Beauty Retail Business of the Year. Of course, we are the defending champions. World-class makeup brands and Kwanyet on, you name it. Maybelline, Dark and Lovely, House of Tara, and many more. Your professionalism in the beauty industry is unmatchable. Bramian the proper way of applying our products. Sigma Health and Beauty, Yewa Accra, Makwala, Georgina Stores, and Rollins Park, Gate 4. Fryer in 0248 138 596 and 0201 408 186. Or visit our online shop at www.beautyavenuegh.com. Sigma, your beauty, our joy.
Welcome to the Ghana ICT Hub, a partnership between MTN Ghana and the Government of Ghana through the Ministry of Communications and Digitization. MTN pledged to support Ghana's digitization agenda in line with its ambition to lead the delivery of digital solutions for Africa's progress. In fulfillment of this pledge, MTN Ghana has committed $25 million toward the realization of the Ghana ICT Hub project. The objectives of the Ghana ICT Hub project is anchored on the following: to create an ICT-enabled environment for human capital and ICT skills development, to develop an ICT ecosystem through remote access delivery to facilitate job creation for national development, to provide a modern, state-of-the-art physical infrastructure to serve as a pillar for the digital Ghana agenda. The physical infrastructure, when completed, will provide 4,000 square meters of space with the following facilities: laboratories for technology training and research, innovation hub, co-working spaces for tech innovation startups, Tier 3 data center, conferencing facilities, offices and meeting rooms, commercial lettable spaces, gaming area, restaurant, ancillary facilities. The technology laboratories will be fitted with the next generation ICT equipment and applications to provide the youth of Ghana with practical training in Industry 4.0 technologies such as artificial intelligence, AI, machine learning, cloud computing, 3D printing, robotics, Internet of Things, IoT, advanced manufacturing techniques, cybersecurity, genetic engineering. The project also seeks to establish a complete ecosystem at the hub through remote access delivery to facilitate job creation for national development. The ecosystem shall comprise of MDAs, technology companies, startups, incubators, research agencies, leading universities globally, foundations worldwide, to create a community. 1. The ecosystem community shall bridge the divide between academia and industry and provide solutions to challenges in the key sectors of health, agriculture, and educational sectors of the economy. 2. It shall also run an innovation program providing mentoring and networking for the youth in tech startups. 3. The ecosystem community shall establish an innovation fund to support startups, research agencies, and other entities in the ecosystem. MTN Ghana and the Ministry of Communications and Digitization are championing the Ghana Digital Agenda for Ghana's development. Welcome to the digital age.
Go Ghana! Are you struggling to pay your huge rent advance? Do you wish to pay your rent on monthly basis? Then good news is here. The government of Ghana has introduced the National Rental Assistance Scheme to help Ghanaians, especially the youth, pay for their rent on a monthly basis. To qualify, an applicant must show proof of the following minimum requirements: be a Ghanaian, possess a valid Ghana card, you must be an adult of 18 years and above, have a verifiable employment or earned income, To apply, visit www.nras.gov.gh. The scheme is currently operational in the following regions: Greater Accra Region, Ashanti Region, Eastern Region, Western Region, Bono East Region, and the Northern Region. For further inquiries, contact 0551 341 515 or 0550 408 879. National Rental Assistance Scheme, making renting accessible for all.
I want you so bad, Alpha Cracker. I want you. I wanna say yes, I can't resist. I want you. Ooh, I want you, Alpha Cracker. I want you so bad, Alpha Cracker.
Don't me call one casa.
Alpha goodness rich in milk and butter. In Alpha Cracker. Yummy and deliciously crunchy.
But I can't resist you.
Alpha Crackers. Simply irresistible.
This advert is FDA approved.
Everyone needs the perfect snack to munch on during a fun moment. Wow. Enjoy the tasty McBerry Twist Cupcakes, deliciously baked and packaged for a sweet treat. Premium quality cakes baked with love for all, enriched in butter and milk. Yummy. Oh, McBerry Twist Cupcakes, simply irresistible. Try one today.
This advert is FDA approved.
Now, back canocre. To sound quite dear one ton and be a man in quite baby.
Mommy, you first can see about Kotoso. People got sending me sick from Lemonade Finance while Brian did the shit and let me £10.
Lemonade Finance.
Say they're sending money back home from UK, Canada, and now US. I accepted a instant charges. Exchange waiting in so ye unbeatable. We should me promo code Dr. Like menya £10, $10 and $10 Canadian dollars for the first transaction. What is Sandy Sika Akofino? Download to Lemonade Finance.